The broadcast is now starting. All attendees are in listen-only mode.
Welcome to the Elder Law Update webinar for 2018. I am attorney Matt Parker, and each year I have the honor of presenting a collection of legal trends and new laws at Marshall, Parker & Weber's Professional Update. So for this webinar, I will give you an abbreviated version of my materials from this year's event. The first topic addresses the recent wave of Medicaid waivers across our country, whose primary purpose is apparently to save the state some money by cutting Medicaid benefits to those people who are really in need of the services. In order to fully appreciate these changes, you have to understand what is a Medicaid waiver and what are these waivers traditionally supposed to accomplish. Under the Medicaid program, states receive federal funding for Medicaid, but the states must comply with federal Medicaid requirements in order to receive those federal dollars. Section 1115 of the Social Security Act allows the Secretary of Health and Human Services to waive some of those federal requirements for states to conduct what are called Medicaid demonstration programs. Historically, these waivers have been used for programs like the transition to managed care that is currently going on in Pennsylvania, and coverage expansions such as to home and community-based care. The language of this Section 1115 provides that the waivers are for experimental projects that promote the objectives of Medicaid. The primary objective of Medicaid is to furnish medical assistance on behalf of low-income and low-resource people. In addition, not all the provisions of the Medicaid program can be waived. Only those located in Section 1902 of the Social Security Act can be waived. There are some non-waivable provisions that include cost sharing, spousal impoverishment provisions, and co-payment limits. Under the current administration, waivers have been granted to many states that are not consistent with the purpose of waivers. Here is a list of the requested waivers as of January 2018. You can take a look at some of the areas of Medicaid programs that are being modified via waivers. They include premiums, cost sharing, work requirements, retroactive coverage, and some prompt enrollments. Kentucky's waiver request was granted and is in the crosshairs of a lawsuit brought by parties who claim it violates the federal law. Their waiver is pretty typical of those being granted by the Department of Health and Human Services. The objecting parties claim that Kentucky's waiver will worsen or eliminate access to those who are in need. Some of the hotly contested changes include a work requirement for those enrolling in Medicaid. If a Kentucky Medicaid enrollee doesn't meet one of the listed exceptions, they will have to prove employment or be disenrolled. Coverage lockouts. Individuals who fail to file paperwork, make premium payments on time, or who fail to quickly report changes in their circumstances will be terminated and prohibited from enrolling for 6 months. Waiting periods for enrollment. Kentucky has a 2-month waiting period prior to enrollment. Premiums and terminations. Kentucky can charge premiums for Medicaid and terminate those who fail to pay. Retroactive coverage has been eliminated, so applications after an incident that requires coverage will not be permitted in Kentucky. So if there's an accident that requires hospitalization, there'll be no retroactive coverage for the hospital care. Other states, including Indiana and Arkansas, have similar waivers that have been approved by the department. As the previous chart indicated, there are scores of other states waiting in line to have their waivers approved. Here in Pennsylvania, the House of Representatives has passed House Bill 2138 that requires our Secretary of the Department of Human Services to seek a waiver to require Medicaid beneficiaries to work. The bill targets able-bodied adults ages 19 through age 64. It doesn't affect older adults or people with verified disabilities. Under this proposed legislation, the able-bodied adults must work 20 hours a week or complete 12 job training activities per month to keep their Medicaid coverage. Any person who fails to meet these requirements would lose their Medicaid for 3 months in the second year of their enrollment. Any failure to meet the work requirements in subsequent periods would result in the loss of Medicaid for 6 months. The bill also requires the target population to report their income every 6 months and to demonstrate their compliance with work or job training. Now, last fall, the Pennsylvania legislature passed a similar bill, which Governor Wolf vetoed. The consumer advocates who are opposed to the Medicaid work requirements have expressed many concerns about the proposed legislation. So while Pennsylvania's current governor is not seeking approval for a Kentucky-styled waiver, a change in that office this fall could bring about a request for these cost-saving measures. Now, the rollout of the Medicaid managed care organization known as Community Health Choices has begun. Southwest Pennsylvania is the first area of the state to transition its waiver and nursing home residents to one of 3 managed care plans. These new plans will cover Medicaid physical health services and their long-term services and supports known as LTSS. This is a new term that includes the various services people get at home or in a nursing home. The aging, attendant care, comp care, and independence waivers are going to be merged into one waiver program called the CHC Waiver. The options and Act 150 programs will not be affected, nor will the life program, as it's already a managed care program. After a court battle, there are now 3 managed care plans available. They are AmeriHealth Caritas, PA Health and Wellness, and UPMC Community Health Choices. Here's a chart showing the phase-in timeframes for the plan. We are now scheduled for 2020 and are known as Health Choices Northeast. Here are some of what we learned from the Southwest rollout. A notice goes out to all Medicaid beneficiaries advising them they have to pick one of these 3 plans or they're going to be assigned to one by the Department of Human Services. The beneficiaries had to determine if their medical providers were in the plan network. Now, for those with Medicaid coverage only, this was really important because the CHC plan is only going to pay providers within their network. So if a person is receiving waiver services, a consumer needs to see if the service coordinator and the waiver providers are in their network. There is a continuity of care provision that requires the CHC plan to pay the existing provider for 6 months once a consumer joins a plan. So there is time to transition out of one provider into another one that's covered by the network. With nursing homes, a consumer can choose any one of these 3 plans. There's an ongoing continuity of care protection for those in a nursing home. Any plan must pay that nursing home if the individual wants to stay in that home, even though it's not in the network. So they cannot force the consumer to relocate. Now, there were plenty of startup issues and confusion in the Southwest. I think by the time the rollout hits the Northeast in 2020, most of these issues will be ironed out. Well, at the end of April of 2018, CMS announced an increase in funding for Medicare programs that affect our skilled nursing facilities. There was an increase to hospice payments and increases for inpatient rehab services. Along with the funding increases came the announcement that CMS will implement a new model for Medicare reimbursement to skilled nursing facilities. The so-called patient-driven model will replace the current resource utilization group system. This was a system that placed Medicare residents in payment groups. The new system is intended to simplify the payment model and reduce the number of groups. This new model was heralded as a way for facilities to reduce their administrative costs. Now, last year, CMS began this move towards revising the reimbursement system. They've been exploring alternatives to the current per diem rates that they claim don't accurately reflect changes in the resources used throughout the resident's stay. CMS believes that payments for Medicare start out low and then they increase as the resident stays at the facility. CMS wants to accurately pay for the services provided to the residents, so they want a more flexible model. There's no guarantee this model will make it to the anticipated rollout date of October 2019. This is the second model that CMS has proposed in the last year. However, it is evidence that CMS is determined to scrap the current reimbursement system. In addition, the home health industry was facing a huge cut to reimbursement rates in last year's budget, but thankfully they were spared those cuts that were initially proposed. However, they're going to face a changing reimbursement system beginning in January of 2020. The new system will be based on a 30-day unit of service. The old case mix system is going to be scrapped. Last year's budget had a host of changes to the tax code. Many of them will affect the financial and estate planning of our clients. For example, there were changes to the 529 college savings plans. These accounts are a tax-advantaged way to put away money for higher education, typically for kids or grandkids. The definition of qualified education expenses was changed to include tuition expenses at elementary or secondary schools that are either public or private. They also now cover expenses for homeschooling. The maximum amount that can be distributed tax-free for these elementary and secondary school tuitions or for the homeschooling expenses is $10,000 per child. The next tax change was to ABLE accounts. Section 529A of the Code authorizes the creation of tax-free savings accounts for those who became severely disabled before the age of 26. These are known as ABLE accounts, and the purpose behind these accounts is to allow those disabled individuals to save money for their own use without affecting their benefits like Medicaid and SSI. There will be no income tax on the earnings in these accounts. So the money in these ABLE accounts can be used for what are called qualifying disability expenses. They include education, housing, health expenses, transportation, and personal support. Annual contributions to these accounts have been limited to the federal gift tax exclusion amount, and that is currently $15,000 per year. The Budget Act changed the contribution rules to provide that once the $15,000 limit had been reached, the disabled beneficiary could contribute their annual compensation to the account. Now, if the compensation of the disabled person is less than the federal poverty level, then the beneficiary can contribute up to the federal poverty level. So the change allows third parties, such as parents, to contribute funds up to the account up to the $15,000, while still allowing the beneficiary to contribute their own income to the account. In addition, funding of the ABLE accounts can now be made by a rollover from a 529 plan. So if there's a 529 college savings account that is not going to be used for a beneficiary with a disability, those funds can be rolled tax-free into an ABLE account for the disabled beneficiary. The amount of the rollover is limited to that $15,000 annual exclusion limit. Next, there were changes to the amount of a charitable contribution that can be deducted in a given year. The previous rule limited the amount of the deduction to 50% of the taxpayer's adjusted gross income. The new rule raises the percentage to 60%. Furthermore, the cash contributions are deemed to happen before all other contributions, maximizing the chance of their deduction in a tax year. The medical expense deduction was modified for 2017 and 2018. Under the existing rule, an individual could deduct unreimbursed medical expenses if they exceeded 10% of their adjusted gross income. There was this separate rule for those taxpayers over the age of 65 who could deduct those expenses if they exceeded 7.5% of their adjusted gross income. Now all taxpayers in tax years 2017 and 18 will be able to use that 7.5% figure when deducting medical expenses on their tax return. Lastly, the federal exclusion amount from federal estate, gift, and generation skipping taxes was increased under the Budget Act. The figure in 2018 was scheduled to be $5.6 million per person. The Act doubles the basic exclusion from $5 million to $10 million. With the adjustments for inflation, the figure in 2018 will be $11.2 million per person. Elder abuse is one of the most underreported crimes in our country. Even those reported cases are very difficult to prosecute. Elderly citizens are financially exploited through telemarketers, email scams, and those who are supposed to look after the seniors' affairs, such as court-appointed guardians. A court-appointed guardian is named by a judge in the Court of Common Pleas where the incapacitated person resides. And the guardian is often a family member who agrees to represent the incapacitated person who can no longer make decisions about their personal and financial affairs. After a court hearing, the court appoints a guardian, and that guardian is given considerable control over the finances and personal decisions of the incapacitated person. The oversight of the guardian is limited to annual reports that generally report the status of the finances and physical condition of the incapacitated person. There are many honorable guardians who faithfully carry out the duties and act in the best interest of the person they are appointed to represent. Unfortunately, of the estimated 1.3 million guardians in our country, there are some unscrupulous guardians who are financially exploiting the elderly. There are stories of abuse involving close family members, such as in the case of decorated World War II veteran Robert Mateva, whose son financially exploited him. Part of this new legislation is named after the late Robert Mateva. Under the bipartisan Elder Abuse Prevention and Protection Act, the Department of Justice would assign an assistant United States attorney to each federal judicial district to investigate reports of wrongdoing by guardians. These attorneys would be empowered to bring in specially trained FBI agents to help investigate the complaints. There would also be a system of information sharing between federal prosecutors in each state that will be facilitated by the Department of Justice. While the legislation does not change the current system of guardianship here in Pennsylvania, it does expand federal involvement in prosecution of guardians. The legislation also requires the Department of Justice to publish best practices for improving state guardianship proceedings, specifically as it relates to elder abuse. This may lead to some changes in the oversight of guardians here in Pennsylvania. Additional provisions in the Act target telemarketing and email marketing to seniors by increasing criminal penalties for related marketing crimes committed against those over the age of 55. Those enhanced penalties also apply to healthcare fraud. Several bills in our state Senate may become law over the next year. The first is legislation that adopts a uniform act relating to digital assets. Our neighboring states of New York and New Jersey adopted similar legislation in 2016 and 17, so it would appear that Pennsylvania will likely pass Senate Bill 827 very soon. For many of us, we have some property stored in digital form. This could be photographs, documents, ebooks, maybe music and movie files. Some of the content is on social media platforms. Others are located in services such as Voodoo or Amazon. There is no longer a physical form for these items, but one that is digital and saved in the cloud. When we die or become disabled, how do our representatives get access to these files? They're not on our computer, but they're saved in a computer server somewhere far away, accessible via a username and password. Can the power of attorney or the executor of an estate go get the digital property and then secure it or transfer it to another party? After all, you paid for those music files. Why can't you transfer them to your kids at your death, just like your parents may have transferred their vinyl records to you? Well, their answer is really complicated. There may be what are called terms of service agreements with the private company limiting what you can do with the saved digital files. Some companies give the user the option to allow the files to be transferred or simply deleted at their death. Unfortunately, the authority of your agent in a power of attorney or the executor of an estate to access this property has not been spelled out in our state law. There is no federal legislation on this topic, so it's been up to the individual states to craft legislation that will address the authority of the personal representatives to access the digital property of those people they represent. Pennsylvania will soon have a law addressing access to digital assets, and that law will be entitled the Fiduciary Access to Digital Assets Act. The law sets forth how 4 types of representatives, executors, guardians, agents under powers of attorney, and trustees can access digital assets. The law will provide that if a person who owns these digital assets doesn't make arrangements with the service provider to transfer ownership of those assets or the account at death, the estate representative can then pass them through the terms of the will, just like you could tangible personal property. This law also deals with the right to access information saved in digital form, such as emails. For example, how many of us have online accounts and receive our monthly bills via email? Agents acting under powers of attorney will often need to access these emails and the accounts when managing the person's financial affairs once they have become disabled. There is an interesting distinction in the law between accessing content of a digital communication and a catalog of that communication. For example, you may have received an email from your credit card company each month regarding your balance due. The fact that you received such an email is part of the catalog that could be received by your agent under a power of attorney. The content is the text of the email. Now, under the proposed law, you can limit access to the content in emails. You can do so through the service provider if they have an online tool like a box you would check limiting disclosure of the content. Or you can limit access others have to the content in a document, such as in a power of attorney or a will. Given what we all suspect might be out there with some of this digital content, some people may want to talk to their estate planner about limiting the representative's access to the content. Two bills in the House and the Senate of the Pennsylvania legislature propose to make POLST orders a standardized part of our healthcare system. POLST in the Pennsylvania bills stands for Pennsylvania Orders for Life-Sustaining Treatment. A POLST order is intended to direct treatment with regard to a patient's end-of-life care. This is achieved by creating a medical order signed by a physician that directs care that is consistent with the patient's goals and preferences for end-of-life treatment. POLST orders provided in a form that can transfer with the patient as he or she moves between medical providers, such as from a nursing home to a hospital. POLST orders are different from advance directives in that POLST orders convert an individual's wishes regarding health care into a medical order that's immediately actionable and applicable across all healthcare settings. In contrast, the advance directives often only name a surrogate decision maker to make healthcare decisions for the individual when they are unable to express their wishes. Right now, the use of the POLST orders in Pennsylvania is largely unregulated. For example, there's no provision in the law regarding training of the personnel who are advising patients about POLSTs. So, if enacted, the current legislation will help remedy the situation. The bills require the Department of Health to develop recommendations for training of healthcare personnel who can then educate patients about POLST or assist in the completion of the form. Some of the other parts of the legislation include regulations addressing what healthcare insurers can require with regard to POLST orders, restrictions on healthcare providers adopting policies that require individuals to have a POLST order, creation of a POLST advisory committee to advise the Department of Health on POLST-related matters, the requirements for a valid POLST order, including a verbal POLST and how a surrogate or a healthcare agent can create a POLST order. Portability and transfer requirements between healthcare facilities are also spelled out, how emergency service providers would deal with a POLST, and how out-of-office DNR orders would relate to the POLST. The bills in both the House and the Senate are very similar, so it's likely that this legislation will be passed in the future. And the Senate bill was sponsored by Lycoming County's own Senator Gene Yaw. A bill introduced in Pennsylvania's Senate proposes to bring Peter Falk's Law to Pennsylvania. The law provides visitation rights to the families of incapacitated persons who are under the legal custody of a court-appointed guardian. The law also gives notification rights to families regarding incapacitated persons' change in residence, admission to a hospital, and eventual death. The late actor Peter Falk played Lieutenant Columbo on the television series of the same name from 1968 to 1978. Wearing a wrinkled raincoat, appearing disheveled and seemingly absent-minded, Columbo would solve crimes with skill and insightfulness. Late in life, Peter Falk developed Alzheimer's disease. He was allegedly isolated from his family and friends by his second wife, who had appointed his court guardian. As his guardian, his wife allegedly prevented Mr. Falk's daughter and family and friends from visiting him. She apparently did not notify them of changes in his health and allegedly failed to notify them of his death in 2011. Peter Falk's story is not unusual. Many families have had similar experiences. Often there is a second marriage, and it has caused a rift between the second spouse and the children from the first marriage. The caregiver spouse refuses access to the children of the first marriage or refuses to notify them of changes in the health, residence, or even death of the parent. Across the country, 12 states have enacted versions of a law that's often referred to as Peter Falk's Law. Pennsylvania's Senate Bill 113 proposes to bring that law to Pennsylvania. The law would prohibit a court-appointed guardian from restricting an incapacitated person's right to visit with family and friends. Now, there may be restrictions on the visitation right, such as to those people who pose a threat to the incapacitated person. If the guardian refuses access, a family may proceed to court to have a judge order the visitation and possibly replace the guardian. Now, the language of the law provides that you can define those individuals who have visitation rights, such as in documents like powers of attorney or advance directives. The law also proposes that the guardian will have to provide notice of the incapacitated person's residence change, admission to a nursing home, assisted living facility, or hospital, and their eventual passing. Given the growing popularity of these laws across the country, Pennsylvania may soon be one of those states granting visitation rights to the families of incapacitated persons. Well, that will do it for this year's Elder Law Update. We had one more topic covered in a previous webinar with regards to the new notary law. So if you're interested in the changes with regard to notarization of documents, do visit that webinar and other topics on our website. We do post on a regular basis. I want to thank you all for attending today.